Thank you, Marco. Good morning, everyone. I am very pleased and glad to be here with you. As Marco already said, I am a lawyer, also a PhD student in law at the University of Athens. Also, I admit that this is very challenging to me because I am speaking to people today who have a technological background. And I have a background in law, so this is going to be very challenging for me. And Marco, I will now search how I can share my screen. I will search options. Let me see if yes, I can.
Yeah, you should. Let me see. It's something. Yeah, we can see your presentation.
Okay, this is perfect. So the DPbDD stands for Data Protection by Design and by Default. I suppose that some of you must be somewhat familiar with this when it comes to technological or organizational measures that should be taken on the part of the controller, on the part of the IT processor, in order to be compliant with GDPR rules or any other privacy set of regulations. So the data protection by design and by default is an obligation that manages to serve as a means to achieve competitive advantage for companies and for whoever enters into a processing operation. I would say I must say that this obligation is irrespective of size and varied complexity of the processing. It is an obligation that must happen before the processing, but also continually at the time of the processing. There is also always a need to review regularly the efficiency of the system. So it is always examined ad hoc. This means we examine the effectiveness of the application of this obligation in the context of the particular processing in question, and this obligation does not require specific measures to be taken. It only requires that we take technological and organizational measures that must lead to the implementation of some guiding principles. These are the main guiding principles that we call data protection principles. We have transparency, lawfulness, fairness, purpose limitation, data minimization, accuracy, storage limitation, integrity, and confidentiality accountability. These all are, as I said, the guiding principles, and we must keep in mind that it is the fulfillment of the aspects of each one of these guiding principles that may become a key performance indicator on the part of the processor, the IT processor, on the part of the controller. And it must be every time demonstrated that the principles, these principles has been taken into account when we're designing the measures in order to be in compliance. The controller must always demonstrate that the principles are being enforced, in particular by the measures, the explicit measures taken, and the controller must always be in a position, be able to demonstrate that the order created, the structure framework of power between the data controller and the data subject is effective. That means that there is always a causal link between the measures, the due diligence on the part of the controller, and in relation to respect of the core of the human right to privacy. So let's proceed to each one of these guiding principles to give a more clear insight about what we have in our minds. So transparency, when we talk about transparency, some key design and default elements for the principle of transparency may include the following, and may include, but it is always suggested to include. Clarity, that means that information shall be clear and plain in language, concise and intelligible. Semantics, that means communication vis-a-vis the data subject should have a clear meaning to the audience in question. Accessibility, that means the information shall be easily accessible for the data subject. Contextual, information should be provided at the relevant time and in the appropriate form. Relevance, that means information should be relevant and applicable to the specific data subject. Universal design, that means that information shall be accessible to all data subjects, include use of machine-readable languages to facilitate and automate readability and clarity. Comprehensible, data subjects should have a fair understanding of what they can expect with regards to the processing of their personal data, particularly when the data subjects are children or other vulnerable groups. One other key design element must be that information should be provided multi-channel, and that means in different channels and media, not only textual, in order to increase the probability for the information to effectively reach the data subject. Also, information must be layered. That means in a manner that resolves the tension between completeness and understanding, while accounting for data subjects' reasonable expectations. I see now a question: what happens if any of those principles are not implemented? I had this in my mind as a conclusion, but as you give me the chance now, I will only refer to the accountability principles. This is the umbrella principle, that if you not respect these principles, it means that the controller is being held accountable for not being compliant. That means that the data subject may raise an action in front of the National Supervisory Authority of Data Protection, may raise an appeal in front of civil or criminal courts, and depending on the level of the non-compliance. And this may imply a series of sanctions, from fines, from orders to stop the unlawful processing. This may imply a compensation on the part of the controller to the data subject for not respecting these principles. I think the National Supervisory Authority may issue some alerts to the controller in order to stop the unlawful processing. So there is a series of sanctions that may be implied in terms of non-compliance, in terms of not respecting these principles. So with this, having in mind this, we can continue to see some examples in order to get more familiar with these guiding principles. So we have one example, which is, you're welcome. You have one example, we have a controller who might be a website owner, and we have on the other part a website user. So on the part of the website owner, the website should not contain a lengthy bulk of information. We see now how the transparency principle is being enforced. So the user of the website can understand how their personal data is processed. Also, the information may be provided in a layered manner, where the most important points are highlighted, where the more detailed information is made easily available, where we have drop-down menus and links to other pages provided to further explain the various items and concepts used in the policy. The multi-channel manner, we can provide video clips to explain the most important points of the written information. Also important is the synergy between the various pages is vital to ensure that the layered approach does not heighten confusion, rather reduce it. So the privacy policy is made available and visible on all web pages on the site in question, so that the data subject is always only one click from accessing the information. So we can say that the whole transparency principle, the aim is to be clear on how the controller will collect and use the data. And it is always important to enable the data subject to use their rights. Another website owner, vis-a-vis the website user, many processing operations using the data collected on the website. A general privacy policy on the website alone is not sufficient for the controller to meet the requirements of transparency. We can have informational snippets or pop-ups, and it must be clear how the personal data will be processed and why the personal data is necessary for the processing. So, as I said, be clear and enable the data subject to make use of their rights. This is all. This is in general what the transparency principle is all about. So we also have lawfulness, and there are also, in this case, some key design and default elements for lawfulness that may include relevance, that the correct legal basis shall be applied to the processing. Differentiation, this is also an aspect. The legal basis used for each processing activity shall be differentiated. We cannot use one single legal basis for every processing. We need a specified purpose. The appropriate legal basis must be clearly connected to the specific purpose of processing. We need necessity. That means the processing must be necessary and unconditional for the purpose to be lawful. We have autonomy. That means that the data subject should be granted the highest degree of autonomy as possible with respect to control over personal data within the frames of the legal basis. And gaining consent must be freely given, specific, informed. Particular consideration should be given to the capacity of children and young people to provide informed consent. Also, consent withdrawal is very important. Where consent is the legal basis, the processing should facilitate withdrawal or consent. Withdrawal shall be as easy as giving consent. If not, then the consent mechanism of the controller does not comply with the GDPR. Lawfulness also relates to balancing of interests. Where legitimate interest is the legal basis, the controller must carry out a weighted balancing of interests, giving particular consideration to the power imbalance, specifically as children under the age of 18 and other vulnerable groups. There shall be measures and safeguards to mitigate the negative impact on the data subjects. Lawfulness also has to do with predetermination. The legal basis shall be established before the processing takes place. And also, if the legal basis ceases to apply, the processing shall cease accordingly. Adjust. If there is a valid change of legal basis for the processing, the actual processing must be adjusted in accordance with the new legal basis. And of course, last but not least, allocation of responsibility is also very important. Whenever joint controllership is envisaged, the parties must apportion in a clear and transparent way their respective responsibilities vis-à-vis the data subject and design the measures of the processing in accordance with this allocation. So if I may make a general comment on lawfulness, I would say that we need to identify the legal basis and in the second place, make sure that the whole processing life cycle is in line with the relevant legal ground of processing that has already been set. So let's see an example now. So we have the bank, which is the controller, vis-à-vis a loan applicant. So keeping in mind the principle of lawfulness, we must consider that the bank procures an online platform for increasing efficiency in the management of loan applications. So there is a need for permission for processing combined with the ability to automatically retrieve personal data from tax authorities. So in this case, the bank cannot use the legal basis of necessary for contract, which is one of the multiple legal grounds for processing. But instead, there is a strong need for another legal basis, and member states have national laws providing for the option of consenting. So we must have by default options. We must have an options environment. Either provide tax information himself, the data subject or herself, or by retrieval from the tax authorities. In this way, we are mitigating the risk for personal data and also the risk for the subject to become less and less involved. So the vital point here is to give the chance to the data subject to become involved and have, as I said, have the discretionary power to choose between giving his permission and giving his information, tax information, or in another way, to give the permission to the bank to retrieve the personal data from tax authorities. The controller has assessed the data protection by design and by default requirements beforehand, and must include all of these criteria in the requirement specification for the tender to procure the platform. It is very important to underline here that the public administration also the private administration of a bank, both they have the responsibility to lead the example, and when procuring platforms for increasing efficiency, they are suggested to include this criteria.
I think we lost her. Are you here? I can see that the mic is moving, but I'm not sure. Let's wait a few minutes if she come back.
Can you hear me?
Yes, you are back now.
I don't know. Mine that has a problem?
Yes, now just a little bit you were like disconnected, but now you're okay.
Okay.
Just share the screen again. Yeah.
Okay.
Okay, perfect.
Okay.
I would suggest, sorry to interrupt you. Maybe if because you have some, I guess, maybe problem with internet, can you turn off the camera while presenting so you have maybe more, how to say, better connection? Just suggestion.
You cannot see me while presenting?
No, we are seeing you, but if you turn off your camera, it will be better your connection. That was I suggesting.
Okay. I will turn off my camera.
Yeah.
It is better now?
Well, we will see, but it will probably be.
Okay.
Thank you.
So, you're welcome. So, in terms of the lawfulness principle, excuse me. Excuse me. In terms, can you see the
screen?
The screen?
Yes, you are the bank. That's right.
Okay, so in terms of the lawfulness, I was saying that it is a primary responsibility for both the public and the private administration. Private administration including the banks, to lead the example, and including all these criteria we have referred to in their requirements specification when they are procuring platforms for increasing efficiency in the management of their services. The controller is aware that if they do not include these requirements in the tender, it may either be too late or very costly process to implement data protection afterwards. So in this case, it is suggested to provide an option environment to the data subject in order to having the data subject more and more involved and more informed, and always able to make sure that the processing is being done lawfully. So we have in next the fairness principle, and some key designs for fairness is autonomy, Data subjects should be granted the highest degree of autonomy possible to determine the use made of their personal data, as well as over the scope and conditions of that use of processing. Interaction. Data subjects must be able to communicate and exercise their rights in respect of the personal data processed by the controller. Expectation. Processing should correspond with data subjects' reasonable expectations. Non-discrimination. The controller shall not unfairly discriminate against the data subjects. Non-exploitation. The controller should not exploit the needs or vulnerabilities of data subjects. Consumer choice. The controller should not lock in their users in an unfair manner. Whenever a service processing personal data is proprietary, it may create a lock-in to the service, which may not be fair if it impairs the data subject's possibility to exercise the right of data portability. And power balance, which is very crucial. Power balance should be a key objective of the controller-data-subject relationship, and imbalance should be avoided. When this is not possible, they should be recognized, and suitable countermeasures should be taken. Excuse me. So fairness has also to do with no transfer of the risk. Controllers should not transfer the risk of the enterprise to the data subjects. No deception. Data processing information and options should be provided in an objective and neutral way, avoiding any deceptive or manipulative language or design. Respect rights. The controller must respect the fundamental rights of the data subject and implement appropriate measures and safeguards, and not impinge on those rights unless expressly justified by the law. Ethical. The controller should see the processing's wider impact on individual rights and dignity. Truthful. That means that the controller must make available information about how they process personal data. They should act as they declare they will and not mislead the data subjects. Human intervention. The controller must incorporate qualified human intervention that is capable of uncovering biases that machines may create in accordance with the right to not be subject to automate individual decision making. And last, fair algorithms. Regularly assess whether algorithms are functioning in line with Can you hear me?
Yes, we can.
Okay, I think I have lost my screen. Regularly assess whether algorithms are functioning in line with the purposes and adjust to mitigate uncovered biases and ensure fairness in the processing. Data subjects should be informed about the functioning of the processing of personal data on algorithms that analyze or make predictions about them, such as predictions on their work performance, on their economic situation, on health, personal preferences, reliability or behavior, location, or movements. So all in all, summarizing the fairness principle, we must say that the data must not be processed in a way that is unjustified, that means no reasoning provided, must not be processed in a way that is detrimental, and in a way that balancing of interests has not taken place, not processed in a way that is discriminatory, not in a way that is misleading or unexpected, and in no way data must be processed in a way that has no respect to the human dignity. So let's move on to an example. we have a search engine operator, a controller, vis-a-vis the user. The controller operates a search engine that processes mostly user-generated personal data. For more extensive collection, the operator needs consent. Therefore, the operator must present options. Options must be presented in equal, neutral way. In no way the option must be invasive. There must be no pressure, and there must be no dark patterns. But there must be provided equal, visible options presenting ramification of each choice for the further processing. So we have another example. We have the operator of a streaming service, who is the controller, and we have the user, the two parts. The users may choose between a regular subscription and a premium subscription. So premium subscription means implies a prioritized customer service. But in no way this service of priority cannot result in a discrimination between the two types of users, I mean the regular subscribers and the premium subscribers. There must be no discrimination between the two in access to exercise their rights. That means their right to have claims responding without undue delay within 1 month to be replied. Subscriber may get better service in terms of functional quality, but must enjoy equal service regarding the enforcement of rights granted by the law. So, in exercising the rights, the two types of subscribers must have equal service. The service is differentiated only in terms of functional quality. So let's proceed to the next guiding principle, which is the purpose limitation. Purpose limitation key design elements include predetermination. The legitimate purposes shall be determined before the design of the processing. Specificity. The purposes shall be specified and explicit as to why personal data is being processed. Purpose orientation. The purpose of processing should guide the design of the processing and set processing boundaries. Necessity. The purpose determines what personal data is necessary for the compatibility. Any new purpose must be compatible with which the data was collected and guide relevant changes in design. Limit further processing. The controller should not connect data sets or perform any further processing for new incompatible purposes. Limitation of reuse. The controller should use technical measures, including hashing and encryption, to limit the possibility of repurposing personal data. The controller should also have organizational measures such as policies and contractual obligations which limit reuse of personal data. And review. The controller should regularly review whether the processing is necessary for the purposes for which the data was collected, and test always the design against the purpose limitation. So all in all, if we want to summarize the principle of purpose limitation, the data must be processed for purposes only for purposes which are specified, explicit, legitimate, and for no further purpose which might be incompatible with the original purpose. And let's move on to some examples. We have the e-shop owner, which is the controller, and we have the customer, the customer. The purpose of the data processing is to fulfill a purchase contract. So there is a need to deliver goods to a correct address in order to obtain the payment. The certain extent of the data stored is purchase history, name, address, email, phone number. So the shop owners is setting a new purpose, which is to better target advertising activities. So he needs a new product, which might be a customer relationship management system for a 360-degree view of the customer, let's say, set of data. The extent of the data store might be sales, marketing, customer service, phone calls, activities, campaigns, all in one. So plus this new product might lead to automatically analyzing the purchase power of the customer. So in order to be in line with the principle of purpose limitation, the controller should ask the product provider to map different processing activities and try to match them with the original purposes. Then he proceeds to an assessment after the mapping, and if the marketing purpose is compatible with the original purpose, this is in compliance with the guiding principle of purpose limitation and the lawfulness. And this is always an ad hoc assessment. That means that it is an assessment that takes place in terms of the particular case in question. Also, we have the guiding principle of data minimization. Let's move here. So there are also, in this case, some key design and default elements that might be included. This is data avoidance. Avoid processing personal data altogether when this is possible for the relevant purpose. Limitation, limit the amount of personal data collected to what is necessary for the purpose. Access limitation, shape the data processing in a way that a minimal number of people need access to a personal data to perform their duties and limit access accordingly. Relevance. Personal data should be relevant to the processing in question, and the controller should be able to demonstrate this relevance. Necessity. Each personal data category shall be necessary for the specified purposes and should only be processed if it is not possible to fulfill the purpose by no other means. Aggregation. Use aggregated data when possible. Pseudonymization, pseudonymize personal data as soon as it is no longer necessary to have directly identifiable personal data and store identification keys separately. Anonymization and deletion, where personal data is not or no longer necessary for the purpose, personal data shall be anonymized or deleted. Data flow, the data flow should be made efficient enough to not create more copies than necessary, and of course, state of the art. That means that the controller should apply up-to-date and appropriate technologies for data avoidance and minimization. So to sum up, let's see what data minimization is all about. That means that here, the principle also of necessity is being operationalized. That means that the data that must be processed, it is only the data that is adequate, relevant, and limited to the necessary extent for the purpose. So let's move on to some examples to get more clear image of what we are referring to. We have the e-book shop owner, who is the controller, vis-a-vis the customer. And the e-book shop owner, the controller, provides one single standardized form for the ordering process. where all fields are mandatory in the contract form. But what we have here, the date of birth is irrelevant to the purpose of purchasing a book from the electronic bookstore. The phone number is not necessary when paying upfront. Where also the address is not necessary when the product is being downloaded to device. So to comply with the principle, one should eliminate unnecessary fields in the contract form, or in another way, the controller might split into multiple web forms for ordering books accordingly to the version of the book order, or the version of payment according to the circumstances. So another example is the public transportation company that is a controller and the user of the transportation means. The purpose here is to use statistics to amend public transport schedules, and passengers pass their ticket through a reader when entering and exiting the transportation means. From the risk assessment point of view, it is possible to identify, it is the risk to identify subjects' working or living conditions, while this is not necessary for the purpose of optimizing public transportation results. So the way out is not to store ticket identifiers to minimize the data, as we said, but to store only the travel routes. So, and if there is still risk of identification, we may apply statistical countermeasures by, for example, cutting the beginning and the end of the routes. So this is in terms of the principle of data minimization, as we referred. And we have another example, the courier company, which happens to be the controller, vis-a-vis the customer. The purpose here is assessing the effectiveness of its deliveries, amending the system, and so the purpose of the processing. So there is an inherent risk. So there is an inherent risk of tracking customers' habits, profiling the individual, which is unlawful. So the way out is pseudonymization solution that implies effective data minimization. It guarantees not crossing the threshold of monitoring individuals' behaviors, where, as we said, the profiling of the individual is in principle not lawful. And we have another example, the hospital, that is the controller vis-a-vis the patient. The hospital keeps an electronic health record system. The hospital staff needs access to patient files for the purpose of processing here. The purpose of processing is informing decision of care and treatment, documenting all diagnostic actions. And the way out in terms of minimizing the data is to provide access only to those assigned to treatment of the specific patient in the relevant specialty department. And the access is being enlarged if other departments are being involved in the treatment. So after the patient is discharged, the access must be reduced to employees receiving and answering requests upon authorization of the patient. So this is a way of minimizing the data. And we have accuracy. That is, some key designs is data sources of personal data should be reliable in terms of data accuracy. Each personal data element should be as accurate as necessary for the specified purposes. Reduce the number of false or false positive negatives, for example, biases in automated decision and artificial intelligence. Depending on the nature of the data in relation to how often it may change, the controller should verify the correctness of the personal data with the data subject before and at different stages of the processing. The controller shall erase or rectify inaccurate data without delay, shall in particular facilitate this where the data subjects are or where children or later want to remove their personal data. Controllers should mitigate the effect of unaccumulated error in the processing chain. Also, access data subjects should be given information about and effective access to personal data in order to control themselves the accuracy and rectify as needed. Personal data should be accurate at all stages of the processing. Tests of accuracy should be carried out at critical steps. Personal data shall be updated if necessary for the purpose, and data design, use of technological and organizational design features to decrease inaccuracy. For example, present concise, predetermined choices instead of free text fields. And let's see the example of the accuracy. As we said, data need to be accurate and up to date because there are potential risks to the data subject that might lead to faulty results. The insurance company, for example, uses AI to profile buyers of insurance. Profiles shall form the basis for calculating the insurance risk. The data protection by design and by default consideration is when selecting the AI application form from a vendor and when deciding how to train the AI. So if we have accurate we have accurate results. So we need a representative pool of customers to avoid bias. We need pseudonymized prior to transfer to the training system. We need only collect data from up-to-date resources. We need test the AI to be reliable and not discriminatory, to have reliable and not discriminatory results. We need to use AI results to support risk assessment, yet not relying solely to the AI results. We need regularly review results from AI, and we need to adjust the algorithm when necessary. And we also have another example, the health institution, that is the controller, vis-a-vis the patients. The health institution keeps a client registers and the treatment journal records. In the client registers case, if two persons arrive in at the same time get the same treatment, there is a high risk of mistake when only the distinguished parameter is the name. So we might need for a unique identifier for each person. And in the case of the treatment journal records, if we have two or more systems in use, there is the risk that a chain system does not appear in the other. So we might need immutable cryptographic timestamps for a continuous recognition, correlation, and tracing of changes. And we limitation, key design, and default elements is deletion and anonymization. Effectiveness of anonymization and deletion. The controller shall make sure that it is not possible to re-identify anonymized data or recover deleted data. It is only cutting off from time. Okay, yes, I see.
Yeah, from
it is cutting off from time to time.
We lost your some word, but you're coming back immediately, so it's, I guess, you cannot do anything.
Okay.
But yeah,
so it is probably my internet connection.
Yeah.
Okay. So automation, that means deletion of certain personal data should be automated deletion. Storage criteria, the controller shall determine what data and length of storage is necessary for the purpose. justification, the controller shall be able to justify why the period of storage is necessary for the purpose and the personal data in question, and be able to disclose the rationale behind and the legal grounds for the retention period. So the controller shall be able to justify why the period of storage is necessary for the purpose, and disclose the rationale behind and the legal grounds for the retention period. Enforcement of retention policies. The controller should enforce internal retention policies and conduct tests of whether the organization practices and its policies. Backups and logs. Controllers shall determine what personal data and length of storage is necessary for backups and logs. And data flow. Controllers should be aware of the flow of personal data and the storage of any copies, and seek to limit their temporary storage. So let's see the example. The administrator, who is a controller, vis-a-vis the member subscriber. The purpose of the processing is the Sorry, excuse me, it is the connection. So the purpose of the processing of an electronic administration is the administration of the membership subscription status. So he suggested to delete data when the status is terminated, and there is no legal basis for further storage. Draw up an internal policy for data retention deletion. Make more effective, less error-prone system via an automatic system. Automatic occurs at a predefined regular period to remove massively from all company storage media data which is no longer necessary regarding to the aim, and review and test procedures. And we also have integrity and confidentiality. We might apply information security management system, risk analysis against the security to assess risk analysis to assess the risk against the security of personal data by considering the impact on the rights and the identified risk. Security by design, which is that is security requirements as early as possible in the system design, and continuously integrate and perform relevant tests. Maintenance, that means regular review and test software, hardware, system, and services to uncover vulnerabilities of the system supporting the processing. We need access control management. We need access control management, access limitation in terms of agents, in terms of the content, and shape the data processing in a way that no individual needs comprehensive access to all data collecting about the data subjects in order to avoid profiling of the individual. Some other key design and default elements is to secure transfers, to secure storage, to the pseudonymization solution, the backups logs in order to have some monitoring and some safety, disaster recovery and business continuity, protection according to the risk. Data presenting special risks, for example, must be kept separated from the rest of the personal data. Security incident response management and incident management. That means that the controller is always in a position. That means that the controller is always in a position to handle breaches and incidents, and that includes notification procedures and information informing the data subjects. And here we have an example. The health institution, the controller, orders a quality assurance company, the processor, to use the data of a patient. The quality assurance company extracts large quantities of data from medical database to a dedicated server of the company. So we have here a risk, and the risk is assessed of routing the extracts to the server. There is high risk that the data might be accessible by all employees. So we need to restrict access to employees of only one department, pseudonymize data before transfer, establish access control to the server, set security monitoring for prevention of cyber attacks, intrusion detection, automated auditing system to monitor access and changes, reporting and automated alerts when certain events related to users are confirmed. And this way, inappropriate use can be quickly, easily detected. We might also apply separate databases on the same server. We might also apply column-level encryption to store them, and also apply keys for data encryption stored in a dedicated security module that's accessible by authorized personnel. So all in all, the umbrella of all these guiding principles, we can say that it is the accountability principles. In order to prove transparency, lawfulness, fairness, purpose limitation, data minimization, accuracy, and storage limitation, and integrity and confidentiality, the controller must be able at any time to demonstrate compliance with all the aforementioned principles. He must demonstrate the positive effects of the measures taken, and he must also demonstrate the reason of the alleged effectiveness. He must, let's say, the controller must provide a causal link between the measures taken, the due diligence shown, and the respect to the core and the respect, a causal link between the measures and the respect to the human right to privacy. And the data protection regulatory set of principles. So this is needed in order to build trust in terms of market, and the controller must be able and must prove knowledge of the common set of rulings, must also prove understanding. He's understanding, he is in a position to correlate objective circumstances and results, and he also has the ability to perform his duty in terms of data protection by design and by default. So that was my humble insight, and my presentation is over.